Dear students, now we move to part C of the session. We have various miscellaneous concepts to understand. Concepts like single citizenship and the exceptions related to that, inner line permit, what are the states which follow inner line permit system, why was that introduced then and why is it still continuing now, what is the difference between PIO and OCI, the Citizenship Amendment Acts made in 2015 and 2019. These two amendments are very important from examination point of view. Then we'll see Assam Accord, NRC and NPR. In India, we have single citizenship. We have countries like the United States of America and Switzerland following dual citizenship, but we follow, like Canada, single citizenship. All the citizens enjoy equal civil and political rights, irrespective of the place of birth, irrespective of the place or the state where the citizen was born. However, there are a few exceptions. Parliament under Article 19 may prescribe qualifications like residence, religion, class or caste for certain type of jobs. What is the intention? The intention is equity, justice, fair play, or development of some section of people who are oppressed and not developed, and various other ideals. So in general, there is no disparity, but Parliament has some kind of power to uplift and make some exceptions under Article 16. So states also can have some kind of exception, like waiving the fee in educational institutions to the residents of that particular state, or giving or reducing the fee for some people or people from that state. They are all exceptions. In fact, we see, for example, Article 371D, which was brought in through 32nd Constitutional Amendment Act in 1974 with regard to local jobs or importance given to locals while considering for some jobs in Andhra Pradesh. Even after the bifurcation of the state in 2014, that is still applicable, but it is applicable to Telangana as well as Andhra Pradesh. Another exception for the free movement. Generally, India, everyone is free to move anywhere, any part of India and carry out business and carry out any other activities. We are free to move anywhere in India. But one exception is this inner line permit. Inner line permit is a travel document issued by the state into which we are entering for a short period of time. Let's say, for example, 15 days or 13 days, whatever may be the duration. That permission to travel for that duration into that state is given by the government of that state. This inner line permit is applicable to 4 states in India: Arunachal Pradesh, Nagaland, Manipur and Mizoram. Arunachal Pradesh, Nagaland, Manipur and Mizoram. These 4 states follow the inner line permit system. Why was that introduced? It was introduced by the British under the Bengal Eastern Frontier Regulations 1873 with the selfish motive or with the business interests they had introduced. They did not want outsiders to enter in those protected areas and carry out business or rob like them the products available there. Probably the primary intention was business, let no outsider enter and disturb the British business which they were carrying on at that point in time. Why are we carrying out or continuing this inner line permit? We have a reason for that. See, the government of India wanted or still continues to retain this inner line permit with an intention to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. The primary intention now is to preserve the culture of the scheduled tribes living there, to preserve the serenity of the atmosphere of those protected areas, to preserve the pristine culture and tradition. These are the motives behind the continuity of inner line permit. Another important point is inner line permit is required by the Indian citizens who want to travel to those states or travel into those states. But foreigners who want to travel in those 4 states require Protected Area Permit, PAP. The difference between ILP and PAP is ILP is required by Indians, PAP, Protected Area Permit, is required by foreigners. Alright? What is the difference between PIO and OCI? Persons of Indian origin and overseas citizen of India. See, we have a number of differences. However, I would like to just state 3 or 4. Persons of Indian origin. This scheme is a scheme under Ministry of Home Affairs which was introduced. The scheme was introduced in August 2002. OCI scheme was operational under Citizenship Act 1955. The source is the Act. It was introduced from December 2005. Even though OCI was introduced after 3 years of PIO introduced, this has become popular. OCI had become popular among the people. There are some countries, the nationals of some countries who are not eligible to apply for PIO. They are Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan and Sri Lanka. Nationals from these countries are not eligible to apply for PIO scheme. Nationals from Pakistan and Bangladesh are not eligible to apply for Overseas Citizen of India scheme. These people, PIOs, can visit India without visa for 15 years. OCI, they can visit India for without visa lifetime. That is a lifetime visa, OCI itself. Remember, these people, PIOs, if their stay exceeds 180 days, they need to register themselves with the concerned FRRO or FRO, Foreigners Registering Regional Office. If PIOs extend their stay beyond 180 days, they need to register themselves with the concerned Foreigners Regional Registering Officer or Foreigners Registering Officer, FRRO or FRO. However, there is no such requirement for OCI card scheme. Right. So, in the year 2000, there was a committee formed under the chairmanship of L.N. Singhvi. That committee submitted its report in 2002. That committee was mandated to study comprehensively the relationship between the Indians and the Indian diaspora living across the globe. What is the relationship now? How can we enhance this relationship with the Indian diaspora? How can we help them, and how can we receive the help or in various fields? Based on that study, there were many amendments carried out to the Principal Act, Citizenship Act 1955. This committee in fact recommended for dual citizenship for PIOs. Remember, the government of India never granted dual citizenship. We are following single citizenship. They recommended for dual citizenship. In 2003, there was another amendment carried out to Citizenship Act, CA 2003. They had made provisions there for PIOs of 16 countries to acquire overseas citizenship of India. They had given opportunity for persons of Indian origin from 16 countries, people living in 16 countries. It is specified in the 4th schedule of Citizenship Amendment Act 2003. You can refer. All right. It includes countries like the United States of America, Canada, Switzerland, etc. However, it was further changed in 2005 through CAA 2005 and expanded the scope. It allowed all the nations, all the PIOs living in all the nations to apply for overseas citizenship of India. However, there are exceptions. Exceptions are 2 countries, Pakistan and Bangladesh. Nationals from Pakistan and Bangladesh, or PIOs from Pakistan and Bangladesh, are not eligible to apply for citizenship, overseas citizenship of India. Now, this is a very important concept. In all probability, this is important for prelims, mains, as well as interview. This is the Constitutional Amendment Act 2015. The nomenclature of Overseas Citizen of India card holder was introduced through CAA 2015. In that year, they merged PIO and OCI and brought them into one. That is OCI Cardholder. It is also known as Overseas Citizen of India Registration Certificate. Right? Who are all eligible for registration of Overseas Citizens of India Cardholder? There are a set of people, there are a group of people who are eligible. Let us see. An Overseas Citizen of India Cardholder or the group of people who can apply for this Overseas Citizen of India Cardholder are a person, it's a standard, any person of full age and capacity who was a citizen of India either at the time of the commencement of the Constitution or after the commencement of the Constitution. Constitution commenced on 26 January 1950. Right. Next, the people who were not citizens but who were eligible to become citizens at the time of the commencement of the Constitution. We have seen under Article 5 and further that who were eligible to be considered as citizens of India at the time of commencement of Constitution. You may refer that. And the people who were part of the territory which was acquired later, that is after 15th August 1947. So we have territories like Pondicherry, Sikkim, Diaspora, which were acquired by India after 15th August 1947. So even those people, even people who were living there were also eligible to apply for this registration. And the major or minor children of this person. Now we have discussed who is that person. That person is who was a citizen of India at the time of the commencement of the Constitution or afterwards, or who was eligible to become a citizen of India, or who was there in the territory which was acquired by India after 1947, 15th August. Right? And the children who were minor and the major, or grandchildren or great-grandchildren, they are also eligible to apply for this registration. Next, a person who is a minor child and whose both parents are citizens of India, or one of them is citizen of India. Any minor child whose both the parents are citizens or any of the parents is citizen of India is also eligible to apply for the registration. Next, spouse of foreign origin of a citizen of India or spouse of foreign origin of overseas citizen of India cardholder. Let's say citizen of India or overseas citizen of India cardholder. These two sets of people, citizen, OCI cardholder. If they marry a foreigner, and the relationship continues for 2 years, then they can apply. The foreign spouse can apply for registration of OCI cardholder. However, there are some exceptions. A person or person's parents or grandparents, any of them, if they had lived either in Pakistan or Bangladesh, those people are not eligible to apply for the registration. This is applicable, this exception is applicable across all the sections. Any national or any relation like father, grandfather, great-grandfather, anyone who lived either in Pakistan or Bangladesh is not eligible to apply for the registration of Overseas Citizen of India card holder. Conferment of rights on Overseas Citizen of India card holder. With regard to rights, the government specifies in this behalf through various means. However, it specifies what are the rights which are not granted to this set of people. Let us see the negative aspect. What are the rights which they don't get? The first one, they shall not be entitled to right to equal opportunities under Article 16 in the matters or in the opportunities in matters of public employment. Next, they will not be eligible for the post of president, vice president. They shall not be appointed as judges of the Supreme Court or the judges of High Court, and they will not be registered as voters, and they cannot contest either the state or central elections, and they will not be eligible to be appointed to public services or posts connected therewith. And there are many other restrictions which will be specified as and when required. However, the government can also waive some restrictions and appoint OCI card holders in public services when the government deems fit. Renunciation of Overseas Citizen of India card. How do they renounce their card? So they have to express it through prescribed manner, declaring their renunciation. The moment they declare, it is processed, and then those persons shall cease to be an Overseas Citizen of India card holder. But there is a catch here. If the spouse of foreign origin or the minor child acquires these cards based on this person, based on the association with this person, they will also stand to lose this card holder membership or this registration. Let us say if this person who is renouncing has married a person of foreign origin, and that spouse received this card. If he or she resigns or renounces, his or her spouse shall also stand to lose the card. Cancellation of registration of Overseas Citizen of India card holder. See, we have seen how the government cancels citizenship. More or less the same rules are stipulated. If the person has obtained it through fraudulent means, and if that person shows disaffection or disloyal to the constitution, or if he engages in trade with enemy country when we are at war, or if that person is imprisoned for 2 years out of 5 years after obtaining the registration. These are all common for even citizenship. But there are two additions. If it is necessary to do so in the interest of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of the general public, the government may cancel the card holder membership. This is another edition. And the marriage of overseas citizen of India card holder. If the court dissolves the marriage, the membership will be cancelled. Even if the court doesn't dissolve, if the person is involved in another marriage, even though he's continuing with let's say one wife or one husband, and he goes for the second one, or she goes for the second marriage, this cardholder membership is cancelled. OCI cardholder benefits. Though the benefits are not specified in the Act, in various other sources we find the benefits. See, they get lifelong visa. However, if we observe in the month of March 2020, there was a deviation from this. The government of India, due to outbreak of COVID-19 pandemic, they've cancelled the visas temporarily. There was some kind of an issue as when the flights went abroad to bring back the stranded Indians. These people, OCI card holders, were not given importance. That was an issue in the month of March, and from there on, of course, it will get resolved once things get better. And there is an exception for visiting FROs and FRROs, and they have parity with NRIs in respect of facilities available to them in economic, financial and educational fields. However, there are some exceptions. They cannot acquire agricultural plantation properties as it is acquired by NRIs. Right, and they shall be treated on par with NRIs in matters of adoption of Indian children. And another important benefit is, as far as tariffs in the airfares in domestic sector is concerned, they shall be treated equally with resident Indians. And while visiting wildlife sanctuaries, visiting national parks, they'll be treated on par with domestic Indians. They'll be treated on par with NRIs in respect of entry fee charge to national monuments, historical sites and museums, and also following the professions like doctors, dentists, nurses, pharmacists, advocates, architects, chartered accountants, etc. But here there is one exception. These OCI card holders cannot do any research work without special permission from Indian Mission or Post or FRRO concerned. If they want to make research, or if they want to work in the field of research, they should get the prior permission from the concerned competent authority. Now we move to the Amendment Act 2019. Out of all the 6 constitutional amendments carried out to Citizenship Act 1955, this CAA 2019 is the most controversial amendment. What does the Citizenship Amendment Act 2019 state? It talks about illegal migrants. Who is an illegal migrant? A person who entered India without either passport or a valid passport. A person who comes to India without passport is an illegal migrant, or a person who comes to India with a valid passport, however, he extends his stay beyond the specified date, beyond the expiry date. That person is also called illegal migrant. This amendment talks about 6 categories of people: people from 6 communities, that is Hindu, Sikh, Buddhist, Jain, Parsi and Christians. These people, the people from these communities who come from Afghanistan, Bangladesh and Pakistan, they shall not be considered as illegal migrants. Remember, Hindu, Sikh, Buddhist, Jain, Parsi or Christians coming from Afghanistan, Bangladesh and Pakistan to India shall not be considered as illegal migrants. However, they should have entered India on or before 31st December 2014. That's the deadline. All the people who have come before shall not be treated as illegal migrants. They will also not attract passport entry into India Act 1920 or Foreigners Act 1946, because if they attract these acts or rules related to this, they shall be fined or imprisoned or punished. That's the reason we are doing away with these acts as well for them. Who can grant the certificate of naturalization to these people? It is the central government, or the central government may stipulate or delegate the authority to some other authority, to someone else to grant. At this point in time, the central government grants the registration certificate of naturalization to these 6 communities of people. One more important aspect: the person who is granted certificate of registration or certificate of naturalization shall deem to be citizen of India from the date of his or her entry into India. Here comes the catch. It is retrospective. Maybe that person, that migrant might have come 10 years before or 20 years before the stipulated date. But if that person is granted citizenship now, it is retrospective. He shall be deemed to be a citizen of India from the date of his or her entry into India. What does it mean? What is the consequence? Any proceedings pending against that person in respect of illegal migration only, not in other respects, in respect of illegal migration or citizenship, shall stand cancelled. That means if 10 or 15 years back there was a case registered against these people, or some kind of legal action initiated against these people on the grounds of illegal migration or citizenship, all those legal actions stand abated, stand cancelled. That is the consequence of this clause, the date of his entry into India. Clear? Next, there are exceptions to this amendment. It is not applicable to tribal areas specified in 6th schedule. They are Assam, Meghalaya, Mizoram and Tripura. It is not applicable to the tribal areas of those states, and the 4 states we have specified under the inner line permit system, even they are excluded from this Amendment Act 2019. And the another important amendment or change brought in was the legal residency. As far as this process of naturalization, that is the registration of naturalization to these 6 communities hailing from Afghanistan, Pakistan and Bangladesh, who came before 31st December 2014, this is applicable. This change, what is the change? It is not 11 years, it is 5 years. The legal residency requirements for applying for the registration of naturalization process is 5 years and it is not 11 years. There is a criticism on this. What is the criticism? See, this is not our personal opinion, but it is, our interest is purely academic in nature, right? This CAA 2019 was criticized on various grounds. One of the grounds which it was criticized was it was not a reasonable classification. Why did they classify only 6 categories or 6 communities? What happened to the other categories? It doesn't stand the test of classification on grounds of objective of law, intelligible differentia, rational nexus. Just simply understand, it doesn't follow the basic principles of classification. Hence, many people criticize it is irrational, unreasonable classification of communities. Another criticism is that, let us say, if even though it is not specified that religious persecution as a ground, let us assume that it is the religious persecution based on which 6 communities from these countries were selected. What happened to Shia, Balochi and Ahmadiyya Muslims in Pakistan? Even they are being persecuted. Hazaras in Afghanistan, they suffer. Rohingya Muslims in Myanmar, they do suffer, they do face persecution. Tamils in Sri Lanka, even they face some kind of persecution or sufferings. They are all excluded. Jews are excluded. Atheists are excluded. People who don't believe in religion, believe in God, even they are excluded. Why this imbalance or unreasonable or irrationality in classification and selection? This is the ground on which this Amendment Act is criticized. And there are some people who say it outrightly violates Article 14. There is no equality. You treat some section of people in one way and another section of people in another way. There is no equality. Article 14 is outrightly violated. There are some people who say, especially in a northeast region, they say that land is limited, resources are limited, jobs are limited. If they flock, if they come in big numbers, there will be economic problems. There will also be political problems. In fact, there are in some states, people observe that migrants are turning out to be major, and they are determining, they are like commanding the political scenario or political future and political atmosphere. This was not taken positively by the locals there. There is a lot of political turmoil and tension because of this. And see, as we have seen, there are even religion cannot be a proper ground for classification for this Amendment Act, where so many other groups of religions or people are being persecuted. We don't even say why, we don't even understand why the Act says only 3 countries, only Afghanistan, Pakistan and Bangladesh. What way we are related to these 3 and not related to other countries? There is no proper classification even there. Some people say that it is a common history which we have with Pakistan, Bangladesh and Afghanistan. If you say common history or British India, we can think of Pakistan and Bangladesh, not Afghanistan. Afghanistan was not part of British India, nor we have too much of common history with Afghanistan. That also is not very rational. And see, if you see in Bhutan, there is a state religion called Vajrayana Buddhism. Why did the government not include Bhutan while framing this amendment? This is also ground on which so many critics criticize. Arguments for CAA 2019. Some people say that Balochi is not an international issue or not our issue. It is Pakistan's internal problem. We need not compare that here. And we are not part of non-refoulement agreement or conventions or protocols internationally. So we are not bound by all the refugee issues surrounded by us. And historical connection, we do have historical connection with Pakistan, Bangladesh, as well as Afghanistan to a certain extent. That's why we have gone for these three countries. And some people who say that there are political, economical turmoils existing in Northeast, they rebut that point, saying that this problem is not only in Northeast, we have this problem across India. So there is nothing special about this problem arising just in the part of Northeast. And some people say it is we are a sovereign country, we decide what to do and what not to do. And there is also some set of people saying, see, we try and do something. Just because we do something, that does not mean we need to do everything. Just because we try to resolve the problem of some people, that does not mean as a country we need to resolve all the problems which are existing there. We try to do something and we move on. Let's not worry about the reasonable classification. We try to do, we wanted to do, and we shall try to do something. That's also to a certain extent an accepted opinion, right? Again, these are the criticism or the views for and against CAA 2019, which are there in the public domain, and our interest is purely academic in nature. With that, we wind up the amendments of 2015 and 19, and we move on to Assam Accord. What is this Assam Accord? I'll just tell you 3 or 4 points about this accord. That's more than enough. It is a memorandum of settlement between two groups. One group is the Government of India, and another group is the leaders of Assam movement. Who are the parties to this accord? The Government of India or representatives of the Government of India, and the other leaders of the Assam movement. The name, there was a movement launched 6 years before this accord. This accord was made in 1985. However, there was a movement in 1979 by All Assam Students Union. Why was there a movement? What were their demands? The demands were identifying illegal immigrants. We need to identify who are illegal migrants. Then we need to deport. We need to send them back to their homeland. That is their demand. Identify, deport. Identification and deportation of illegal immigrants was their demand. Whose demand? AASU, All Assam Students Union. After 6 years of agitation, there was an accord made between this group and the Government of India. For recognition as citizen, this accord sets March 24th, 1971 as the cutoff date. This is also a very important MCQ. What is the cutoff date as per Assam Accord? March 24th, 1971. You may not get the direct question. The idea may be reflected in the question. Another aspect of Assam Accord is Clause 6. What is that? Constitutional, legislative and administrative safeguards. What is the purpose of Clause 6? What is Clause 6? What is the purpose of Clause 6? Clause 6 is constitutional, legislative and administrative safeguards to be provided by the Government of India, which are required or which are appropriate. For what purpose? To protect, preserve and promote. We need to protect the culture. We need to protect the social linguistic identity. We need to protect the heritage. We need to preserve and promote the same of the Assami people. That is the purpose of Clause 6. It's very important. Then what happened towards that end? In 2019, the Government of India formed a committee under Justice Biplab Kumar Sarma. Who is the chairman of the committee? Biplab Kumar Sarma. This committee has submitted a report, and this report defines, in fact it was not made public officially. It was made public by the Assami Union, and then there was a lot of controversy there. Just out of that report, we'll try and see a few points. According to this report, they say Assami people are indigenous community residing in Assam before 1st January 1951. Then all the other citizens residing in the territory of Assam before 1st Jan 1951. That means indigenous community and the other people also living before 1st Jan 1951 and their descendants. They shall be considered Assami people. Next, they have given all sorts of reservations, 80 to 100% reservation in parliamentary seats and Group C, D posts, and undertaking maybe jobs under the Assami government and the state government undertakings and all those things. They also wanted inner line permit regime. They wanted, or this committee recommended for inner line permit regime in that state. As of now, they don't have ILP regime. What is NRC? The National Register of Citizens. Primarily, it is intended to identify foreign nationals. It is a register containing names of all genuine Indian citizens. At present, we have only state of Assam maintaining NRC, and there were a lot of issues with regard to NRC, and in the year 2013, the Honorable Supreme Court stepped in and demanded for the update of NRC, and the final NRC was prepared in August 2019. In fact, 33 million people, they had to prove that they are Indian nationals, and they were Indian nationals prior to March 24th, 1971. Why this date? It is the cutoff date as given in Assam Accord. Right? In fact, 1.9 million applicants failed to make into the list, and it is one of the contentious issues. In the process of proving themselves, what were the documents used by these people to prove their citizenship? They could use citizenship certificate, passport, government issued license, bank account, post office, land and tenancy records, LIC policy, government employee certificate, birth certificate, refugee registration certificate, electoral rolls up to 24th March 1971. See, all these documents were accepted while proving their citizenship. right? See, in fact, we have seen 33 million people had to prove that, and they have used all these documents or any one of these documents to prove their citizenship. What happens to those people, 1.9 million people who were excluded from NRC? Of course, we have tribunals in place. They can approach the tribunals and they can move to higher courts, a high court, and they can also move to the Supreme Court. We have a mechanism to resolve that issue. That's tribunals, high court, and the Supreme Court. Nehru Liaquat Pact. This is a pact which was made in 1950 between India and Pakistan, signed by the two Prime Ministers, Jawaharlal Nehru and Liaquat Ali Khan. It's a bilateral treaty. What is the purpose of this treaty? It was for refugees. Refugees were allowed to return to dispose of their property. Abducted women and looted property were to be returned. Forced conversions were unrecognized, and minority rights were confirmed. This is the purpose. Because at that time, after the partition, there was a lot of chaos and confusion. Properties were left as is where is condition, and people were migrating from this side of the country to the other country, and from there to this country. There were a lot of commotion and chaos happening. At that time came this Nehru Liaquat Pact. Remember, the purpose is to allow those refugees to dispose of their property. Abducted women and looted property were to be returned. Forced conversions were unrecognized, and minority rights were confirmed. Minorities in both the countries. The National Population Register is a register of usual residents of the country. What is the purpose of NPR? The purpose of NPR is to create a comprehensive identity database of every usual resident in India. Usual residency is defined as a person who resides in a particular place for more than 6 months, or a person who intends to reside in a place for more than 6 months. So those people who collect the data will ask the question, are you residing here for more than 6 months? Yes, then collect the data for NPR. If not, are you intending to stay here for more than 6 months? Yes, then collect data. What sort of data they collect? They collect like the names of the persons, head of the family, father's name, mother's name, place of birth, date of birth, sex and nationality, and all the other information. At what levels do they collect? Village level, town level, district level, state level, central level. At all levels, the data is collected, collated, stored, digitalized. What is the present status? In fact, in 2010, with the census, we have collected all the data, and at present, the government intended to collect data along with this 2021 census between April to September 2020. However, due to a pandemic, maybe once the things settle down, we may go for this updation of NPR. Next, UNHRC, the United Nations High Commissioner for Refugees. It is UN Refugee Agency. It was started in the year 1950 after World War II. Its primary purpose was to help the stranded Europeans after World War II, to help the refugees who were left abandoned. No, there were millions of refugees across Europe after the World War II. They wanted to help them, they wanted to support them, and then after 3 years of their support, they wanted to abandon this agency. However, even after 70 years, this is still working and working very effectively. In fact, it has been saving millions of lives and helping people, protecting rights of refugees. It is in fact the refugee agency, not only the UN refugee agency, it is the world's refugee agency. It's our personal opinion, right? And one important aspect is this work is based on 1951 Refugee Convention and its 1967 protocol. It is also considered as the guardian of this convention and the protocol made afterwards. With this, we have completed the session on the citizenship. We tried to cover almost all the aspects related to citizenship. However, if there are any areas which are left out, or if there are any updates which come before your prelims 2021 or mains 2021, we will definitely come up with additional lectures adding to the existing points before prelims and mains exams of 2021. Friends, we have created this YouTube channel exclusively for the lecture series 2021 for prelims and mains. Please do subscribe and share this to the people who are in most needy. If you don't require these lectures, please share to the people who are in need of these lectures. If you really like our lectures, please press the like icon. And if you have not liked, please do press the unlike button. And we are open to the constructive criticism. You may give us your feedback on iasviewpoint@gmail.com. Please do share the information to the most needy and share this video to the most needy. Thank you.